Hello viewers, how are you all today? Moving ahead in the series of general defenses against torts in the course of law of torts, we shall discuss the next three major general defenses of statutory authority, judicial and quasi-judicial authority, parental and quasi-parental authority. So starting with the first topic, that is statutory authority as a general defense in torts. So if someone acting with statutory authority hurts someone else, that does not constitute a crime and no legal action can be taken. Statutory authority is defined as power that derives directly from the legislature. Even if such action would have qualified as a tort under normal circumstances, it would not be if there is statutory authority. However, if there is a provision for compensation for that specific act, the person may receive it, otherwise not. This statutory authority grants the state and its authorities the ability to act for the welfare of the people, and if any harm is done to anyone while doing so, they will also be immune from that specific conduct. This particular legal principle, rex non potest pecare, that is, that the king can do no wrong, is where the state derives its statutory authority for sovereign immunity. This was previously employed in England to protect the king from accountability. The doctrine exempts the state from being held liable for the torts committed by those working on its behalf. It mainly resulted from two factors. One, because it was a sovereign attribute, it could not be sued without its permission in its court. And the second is the Crown's treasury is impacted by the compensation decision. Thus, sovereign immunity serves as an apparent justification for wrongs done by the state or its agent on the basis of public policy. The accident theory, which disproves real claim for damages in Indian courts, was left up to the judge to determine whether this doctrine complies with the Constitution for a variety of reasons. British rule predated our independence. Therefore, they previously had sovereign immunity for the benefit of populace. The phrase sovereign and non-sovereignty were used in 1893 to determine the East India Company's culpability for crimes committed by its employees. By dividing the tasks performed by the East India Company into sovereign and non-sovereign immunity, C.J. Peacock was able to determine the vicarious liability of the company. Following a landmark decision in which the Court of Madras stated that the East India Company's immunity only applied to what we refer to as Act of State, and that the distinction between the sovereign and non-sovereign bodies need to be clearly defined, and that they should function well in accordance with that, the courts presented two opposing viewpoints in this case. The state of Rajasthan versus Vidyavati was one of the most significant instances to occur after independence. In this case, a government employee improperly operated the vehicle, injuring a pedestrian in particular. The state was not permitted to invoke sovereign immunity in this case, and the court instructed the state to make restitution to the victim. In another case of Kasturi Lal versus State of Uttar Pradesh, the court adopted a radically different perspective of the state and its sovereign authority that it can employ against citizens. The case is the polar opposite of the cases previously addressed. Confusion resulted from the combination of these factors. By distinguishing between the sovereign and non-sovereign functions of the state and holding that the abuse of power used by the police in this case falls under the sovereign immunity of the state, the Supreme Court followed the guidelines established in the POS Steam navigation case and held that the state is not responsible for the actions of its servant, that was police in this case. It is difficult to draw a clear distinction between the two, especially if we want to distinguish between the sovereign and non-sovereign functions of the state. The Vidyavati case was then clearly differentiated by the court. In this case, it was determined that a state cannot exercise its authority arbitrarily in the guise of sovereign immunity because the authority granted in the Kasturi Lal case was conflicting and was found on state governmental power. The court ultimately concluded that the legislation relating to sovereign immunity is inadequate and that the only way to correct the situation is for the government to define and restrict the power and only for it to be used for the benefit of people and no other purpose. The court stated, maxim that king can do no wrong or that crown is not answerable to people for any violation thereof. In the case of state of Andhra Pradesh versus Challa Ramakrishna Reddy. Therefore, the choice of exemption, which may be a statutory justification, cannot be applied solely in cases of fundamental right violation because the state cannot use statutory authority to defend the violation of the fundamental rights and the state's rights cannot be used to override the fundamental right. The procedural side of this was that the party who was wronged might effectively submit a petition in the trial court for a tort the state had committed without having to go via Article 32 and Article 226. Although the court concluded that the Kasturi Lal case was of no consequences and had no legal weight, it failed to take into account situations in which other legal rights rather than basic rights might have been violated. If it becomes necessary to overturn the Kasturi Lal case, only a constitutional bench of 7 or more judges must resolve the case. Now moving on to the next general defense, that is judicial and quasi-judicial authority. Let's understand first the meaning of judicial acts. A judicial act is a decision made by a competent authority that takes into account the facts and circumstances, imposes liability, or affects the rights of others. Judicial acts are those that a certain competent authority completes after considering the relevant facts and circumstances. The law requires judges to render judgments in accordance with all court rules. Judicial acts are performed by judges or other judicial officers in the course of their official duties. A judge may raise this defense if an atrocity is committed against him. According to the law, judges cannot be held accountable for any actions taken or words said while performing their duties. The distinction between judicial and ministerial acts is that a judge is said to be acting judicially when he is dealing with a particular matter and must use his discretion or power to make a decision. Conversely, he is said to be acting ministerially when he is only required to perform a specific act and is restrained from discussing the merits of the matter. Additionally, according to the Judicial Officers Protection Conduct of 1850, any judge, magistrate, collector, or any person acting judicially shall be liable for any act done by him in the discharge of his judicial duties and shall not be prosecuted in a civil court. Before allowing such a defense, the court must ensure that the following two requirements are met. 1. The act must be performed in the course of the court's judicial job. And 2. The judge must act within his or her jurisdiction or at the very least have a good faith belief that he or she has jurisdiction to act. In addition to judges of regular civil courts, members of naval and military tribunals of inquiry established in accordance with the military law and customs are also subject to this immunity rule in judicial acts. In a restricted sense, it also applies to arbitrators and those who are appointed to positions similar to those of an arbitrator. If the individual makes the decision honestly, he is not responsible for any errors in it. But he will be held accountable if any dishonest or partisan activities take place while he is in office. But if he exercises complete judicial discretion, he cannot be held personally accountable and his judgment cannot be challenged as to its accuracy or competence. Now let's see what are quasi-judicial acts. Now, meaning of quasi-judicial acts: the word quasi comes from a Latin word that means similar but not exactly. The quasi-judicial proceedings differ slightly from court proceedings. They are not recognized as courts, although appearing to have some of the rights and requirements of some law. Some organizations and people, such as colleges, societies, and institutions, have quasi-judicial functions and are therefore immune from civil accountability. As an illustration, consider the duties of commissions like the Human Rights Commission and tribunals like the Income Tax Tribunal. Typically, they don't adhere to any judicial procedure. These actions are carried out by people who do not hold judicial authority under specific statutes or who are not judges of any courts. The institutions may employ a management or chief who will have the authority to make choices about how those institutions will operate. These quasi-judicial organizations abide with natural justice principles. They may establish certain suitable regulations in accordance with the law that apply to them and with the customary rule in order to function effectively. Court proceedings are not what quasi-judicial acts are. Even though they may perform the duties and have certain legal rights, they are not courts. Typically, they don't adhere to any judicial procedures. Quasi-judicial refers to a non-judicial body with the authority to interpret the law. It is a body with authority and procedures resembling those of a court or judge. And it is its responsibility to discover the truth and draw conclusions from it in order to serve as the basis for official actions. The fundamental need for actions to qualify as quasi-judicial is that the people who perform them are immune from civil accountability if they follow the natural justice principles as well as specific statute provisions that may specify how they should proceed. As a result, these measures are a response to a problem or the application of a legal sanction, and they may have an impact on some person's legal rights, obligations, or privileges. As a result, no individual may be unlawfully fired or expelled from the organization without providing all of the three following: 1. A fair chance to be heard; 2. A chance to defend himself; and 3. A chance for the person expelled to act in good faith, that is, with proper care and attention. So with this, we move on to our third aspect, or the third general defense, that is parental and quasi-parental authority. Parental authority, as defined by tort law, is the power granted to parents to discipline and manage their children using any form of force, and such individuals are only protected under tort law if they act reasonably and with justification. The judge will determine whether or not the actions were justified. The Hindu Minority and Guardianship Act of 1956 and the Guardians and Wards Act of 1890 both give guardians the authority to sell or transfer movable property or a minor's real estate for the benefit of the minor. Like when a kid is born, parents have certain right over the child and obligations towards them, including the right to education, the right to choose a religion, the right to custody, the right to supervision, protection, and health care. The mother and father are the child's natural guardians according to the Hindu law. A guardian is a person who looks after a minor's needs and belongings. Parents naturally inherit the responsibilities and rights of guardianship at the birth of a child. The natural parent has a responsibility to raise the child. Regarding the custody, education, management, correction, and chastisement of child, as well as their upbringing, both parents have equal rights. The parents hold the key to a child's future. As a result, parents are granted the authority to discipline their children using any means necessary. These individuals are only covered by the tort law if they act lawfully and in good faith. Various constraints must be adhered to in order to meet the needs of the society. However, the judges or the jury's definition of what is proper varies over time. Therefore, there is no set procedure. In order to improve his or her child's behavior, the father, mother, or any adult acting as the child's guardian may use moderate and acceptable corporal punishments. The 1933 Children and Young Persons Act safeguards this protection. Now let's see that what are the rights of parental authority under law of torts. The first one is right to custody. The custody of a child belongs to their parents. They go above and beyond for their kids. The second is right to determine the religion. We are aware that Hinduism, Islam, Sikhism, and Christianity are the four primary religions in India. Parents have both the right and the obligation to decide their child's religion. He is regarded as a Hindu if he was born in a Hindu family, a Muslim if he is born in a Muslim family. It is a parental right that cannot be waived. The third is right to education. As one of the fundamental requirements, education is something that every parent must offer their children. Education is crucial for a successful career. One cannot survive in this world without education. Number 4 is right to supervision. Parents have certain rights towards their children if they uphold their obligation to them. One of them is the right of supervision, which allows parents to keep an eye on their kids' activities and prevent them from engaging in any unlawful or wrongful acts. If they participate in any activities, they make efforts to improve the child's situation. The fifth is right to control. This right is crucial to the welfare of children. The capacity for control allows parents to step in and protect their kids if they feel unsafe or that they are behaving inappropriately. While parents should allow their children to make their own decisions when they turn 18 and become legally adults, this is not always practical because kids have their own personal life after that. Right to reasonable chastisement. Parents have the right to punish their kid for misbehavior in a fair and reasonable way. Parents discipline their children because they always love and respect them. When there is love, discipline is always present. Some relationships are built on mutual respect, faith, and compassion. Chastisement puts a lot of emphasis on respect. Number 7 is right to protection and health care. As is well known, the COVID-19 situation places a premium on health. Life is equally essential to everyone. It is the duty of parents to safeguard the lives of their children by giving them wholesome food, nourishment, and vitamins, as well as by providing appropriate medical facilities and taking care of them. Now let's understand that what is a quasi-parental authority under the law of torts. Let's see the meaning of quasi-parental authority. The Latin term loco parentis, which means in place of the parent or a person acting in a parental capacity, is the source of the English term quasi-parental. Compared to a parental authority, a quasi-parental authority has less privileges. The other individuals is likewise able to get responsibility delegation from the quasi-parental authority. Others include the child's school, neighborhood parents, or nearby relatives. For a period of time, the babysitter also serves as a quasi-parental authority. A teacher's or a school master's authority is comparable to a parent. It is quasi-parental authority because it resembles parental authority. The head teacher, superintendent, or warden of an orphanage, hostel, or children's observation home, among others, are examples of people with this level of authority. Insofar as it is required for the kid's well-being, a parent who places his or her child in the care of a schoolmaster transfers to the person all of their own authority. Therefore, the teacher has the authority to give his student a mild reprimand. This authority may also apply to things they do on their journey to and from school. So it is not just limited to things they do there. However, according to the law, both parents and quasi-parents have the right to discipline a child for their own good or to stop him from hurting anybody else. They are able to correct him at all times because they have legal custody of the kids. A babysitter who looks after the child for a specific period of time and assumes parental duties is another option for parents. Similar to this, parents are assumed to transfer responsibility to teachers when their child is enrolled in school. The fact that both parents and semi-parents in this situation have the legal right to their children is the most crucial aspect of their rights. There is no transfer of rights or obligations under parental authority, but there is some delegation of obligations and rights under quasi-authority. Take the authority that parents grant to their principal or tuition master at the school where their children attend as an example. In order for them to effectively study and accomplish their future ambitions. This is in the child's best interest. Nanny or the babysitter also serve as a sort of de facto parent. The learner needs a quasi-parent to teach them social conventions and how to function in society. In the end, humans have to do things for society. To conclude, this parental and quasi-parental power shields those who act in the child's best interest from responsibility. For the welfare of the kid, parenting comprises a lot of duties and privileges. As a result, you have the authority to gently correct him with words or scolding. A wise man, according to the court, would have considered the punishment appropriate. Along with these rights comes the responsibility to direct the child in the right path and to chastise him with words or gentle corrections. This, however, cannot be used as an excuse to get out of commitments under the law or to commit crimes like assault or violence. The legal system determines how to define reasonableness. The punishment administered must be of the kind that a wise man would consider fitting. With this, we come to the end of our today's lecture. Thank you very much.